3, 2, 1.
Honorable Court of Appeals Tennessee is now in session.
Thank you. Before we have the case called, I just want to mention that we don't anticipate any technology problems, but if we should have any difficulty, everybody just take a deep breath and pause, and we'll work through it and pick back up. Call the case, please.
Jeremy Khristian Abney versus Kaitlynne Nichole Pace.
We'll hear from the appellant.
May it please the court. Your Honors, we're here on strictly a child support case. I know that it's very, very rare. I've never appealed a child support case before, and the reason being we have very specific guidelines, which typically make it very easy, very cut and dry. It's rare for me to even try a child support case for that reason. However, I think in this case, this all stems down to my very first issue. Each of my following 3 issues all stem from this first issue. The first issue being whether the trial court erred in failing to give the mother credit for the health insurance she carried for the child. In this particular case, at the time the parties divorced, the father was ordered to carry health insurance for the child, and he was given credit for that on the worksheet. Subsequently, father did not provide insurance card to the mother and did not provide any information to her. And so when it became available through her work at a reasonable cost, she obtained insurance for the child. As it came on our very first day of trial on this case, at that time, the father did provide the insurance card for the insurance which he had been carrying. However, it took until we got to trial for the mother to receive said card. Now, pursuant to the child support guidelines, the child support shall include adjustments that account for each parent's pro rata share of the child's health insurance premium. The guidelines state if health and or dental insurance that provides for the healthcare needs of the child can be obtained by a parent at a reasonable cost, then an amount to cover the cost of the premium will be included in the calculations of child support. Based on those guidelines, the presumptive guideline amount would include the amount that mother paid for her health insurance for the child. Now, the trial courts have a certain amount of discretion and are able to provide for a deviation if they follow the required standards to enter a deviation. If a deviation is established, the trial court's order must contain written findings of fact. They have to state the reasons for the change or deviation from the presumptive amount. They must state the amount the child support would have been absent a deviation, and then how, in its determination, the application of the guidelines would have been unjust or inappropriate, and the best interest of the child will be served by the deviation for the presumptive amount. In this case, our trial court found that this additional healthcare coverage was not a reasonable necessity or requirement. That simply is not the correct standard. The court did not enter any findings of fact regarding why this would be unjust or inappropriate to follow the standard child support guidelines. It did not state what the child support amount would have been had it not made a deviation, did not state why the best interest of the child was served by having a deviation. So in this case, trial court abused its discretion by following the incorrect legal standard per Armbruster v. Armbruster. Now, in addition, very clearly in Jones v. Jones, because the trial court did not make any written facts supporting a deviation from the guidelines, the appellate court must overturn the trial court's decision. It simply stated she should have gotten credit, and if she wasn't going to, the trial court needed to say why. The trial court didn't say why. This mother provided health insurance for her child, which was used, and the court did not say any reason why it wouldn't be in the child's best interest to have double coverage.
Well, let me ask you, counsel. I mean, the court did find that the father was ordered to provide health insurance, correct?
Correct.
And the court did find that father provided health insurance, correct?
Yes, that he did.
Okay, are those not findings?
He made those findings. However, he also failed to make a finding that father did not provide this health insurance to mother, who was the primary parent. She was unable to use this health insurance. The insurance may have existed, but per the testimony, and that which was in the record for this court, the mother did not have access to that health insurance and was forced to use her secondary insurance.
Counsel, I mean, was there, and I don't know whether or not the record shows this or not, but the health insurance that mother provided that covered the child.
Yes.
Were there any other children that were covered by that insurance?
Yes, she had a second child that she had added as well.
All right. So was the premium that you say was paid for, how did that break out just to cover the child at question here?
The amount that she was requesting was half of the amount to add children, because it covered a second child who was not subject to this child support order. So per the guidelines, take the amount to add the children, take the employee, subtract that out of the employee plus children, and then divide it by 2 for the 2 children, and just use one of the children.
Were the coverages identical? In other words, were there?
It was not the same company, so my guess is not exactly identical, but I cannot tell you for sure. I have not compared the coverages between the 2 insurances. I do know that mother did testify that she did have to use her secondary insurance because she had not been provided access, although she had requested the insurance cards, and she did not receive it until the day of trial, that she was provided any information about what health insurance the father had gotten for the child. In addition,
I'm sorry, but I'm not sure I understood. Did the amount that mother paid for the insurance that covered the child, was it increased more than it would have been if she had had only one child?
I don't believe so. I believe it was the same cost if she had just had one.
Sure. So make sure I understand. So the amount that she's claiming as credit for would have been what she would have paid to have coverage on her other child.
Well, she's only asking for credit for half of the amount.
I understand.
Right. But yeah, she would have had to pay the whole amount. Yes.
Yes, you would have had to pay the whole amount. It would have covered whether she had 1, 2, or more children.
Correct.
All right. Thank you.
But the fact of the matter is that insurance did cover that child. She did carry the insurance, and she did use the insurance. And it was a very reasonable price. I don't have the exact figure off the top of my head, but it was a very reasonable price. Now, the remaining issues that we have argued stem directly off of whether or not mother should have gotten credit for that health insurance.
So let me ask you then, so the variance then is not an issue, because looking at the math on it, it seems like to me it's fairly clear on this record there was a 15% variance. Would you agree?
Not if her insurance premium was included. That's where the issue comes in. Yes. So the issue being, if she had credit, it was such a close amount on the numbers that if her premium had been included, there would not have been a 15% variance. And so that's why the remaining issues that we have before your honors stems off of this first issue. They become not relevant if your honors find that it was correct not to include her insurance. Okay. So if mother's insurance had been included, we would not have met a 15% variance. And then based on not meeting the 15% variance, father would not have been able to have been found to have purged his contempt because the child support would not have been modified. So
I keep going back to this, but did your client say that should she testify that she would not have obtained coverage that covered her other child?
I don't believe that she did testify to that. I don't know if she had other insurance for the other child. It became available to her through her new employment. She didn't have insurance that she was aware of on this child, so she got the insurance. I do not know, and I do not believe that she testified about what was available for her other child, if that was being provided by that father or not. But I know that she testified that her motivation for getting the new insurance was because she had not been provided the information from Mr. Abney in this case. It just happens that it covers all the children that you have for the same price, which is the reason she was only asking for a 50% of that amount to be placed in the worksheet for her. So, Your Honors, we would argue that she should have gotten this coverage for the health insurance placed on that worksheet, as the court did not apply the correct standard, did not make any specific findings, no best interest even mentioned in the ruling, and it would then follow that there was no significant variance. Therefore, support should not have been modified. Therefore, father did not purge his contempt, should have been found in contempt, ordered to purge it, and therefore mother should have been awarded her attorney's fees. And in this particular case, if your honors had a chance to read all the way to the end of the court's ruling, the mother was essentially forced to let go of her claim for attorney's fees because the court would have then also awarded attorney's fees for father based on the modification of the child support, as she determined that my fees were probably less than those of Miss Conklin, and that would be cheaper for her.
Well, but did the parties waive the request for attorney fees?
I guess I would say sort of. I think the court said either both of you
that's
waive.
a lawyery answer, sort of.
Right. It was essentially well, if I award you fees, I'm going to award him fees. So whose fees do you want to pay? Your own lawyers or the other lawyers? So he kind of made his ruling and then said, you decide. I guess would be, that's why I say sort of.
And what was the trial court told?
Both parties said that they'll pay their own attorneys.
All
so.
Right. Anything else, counsel?
No, your honors, I'll save that for my rebuttal. Thank you.
All right, you have your time for rebuttal. We'll hear from the appellee. Counsel for the appellee.
Yes, good afternoon, your honors. Thank you for allowing us to do this by Zoom. It definitely makes things easier on everyone, I believe. I hope you guys enjoy it. Just a few points. I know that you—
Enjoy is probably not the right word.
Make do. You make them do with it. I know that you guys pour over these records extensively. I know that you've read the briefs, so I won't spend a lot of time on that. I just want to hit on a few points made by counsel for the appellant. The very first issue she brought up was that mother was forced, or she testified that she was forced to get insurance because she did not have insurance coverage proof from father. I want to point out just a few things because I believe that may be a slight misstatement. She did testify that she did not have access or didn't have cards, but when she first received insurance through Rutherford County Schools, where she was working, that was in August of 2019. The parties were not divorced yet. The final decree had not been signed yet. I'm sorry, 2018, not 2019. The insurance that father was providing for the minor child had not changed. It was the same insurance that he had been providing throughout the entire life of the child, and nothing had changed. I think what counsel is probably referring to, during our second day of trial, Miss Pace was able to obtain employment through Cannon County, and there was an occasion during the proceedings after we filed our petition that Mr. Abney's insurance companies changed. That may be what she's referring to, but that was after the proceedings had already began, and there were some issues getting that resolved. Her coverage, however, was not because she did not have access to Mr. Pace's coverage. She already had that in place in August of 2018, just as the record shows. Her statements, or her income statements from 2018 are in the record as exhibits. I believe they're in volume 1, and they show that $130.11 was already coming out of her checks back in August of 2018. And again, I won't spend a lot of time on that, but what's very frustrating about this case is that was during the divorce. None of this information was provided to us, and I know it's not before your honor today, but it makes it a very emotional case for Mr. Abney because this information was not provided before the final decree. So I just wanted to clarify that one point. She already had insurance coverage. Your honor, Miss, you hit on something specific that I actually questioned. We don't know who all was covered by this insurance. I assume she was covered. I assume her other child, Christopher, was covered. We don't know if the child of this case was covered. There has been no definitive proof on that, and there's nothing in the record that tells us that. There was no testimony that showed that he was covered. And I definitely know there's nothing in the record that shows that she used this insurance for the child in this case. Even so, I'll get off my soapbox on that, because I believe you guys have read my brief and you know that I've done the calculations. Even so, I based upon the number that was provided in the record and that Ms. Pace testified to, it still meets the 15% variance. And I'll leave it at that. I don't think we need to waste a lot of time. If I can pull up the calculator, we can do the numbers together, but based upon what information was provided during trial, and I cited to the record, she stated that she paid $51.53 per month for the minor child. $51.53, yes, Your Honor. $51.53 just for the minor child of this case while she was working for Rutherford County. She was not working for Rutherford County by the time we went to trial. So we're talking about a period of 1 year from August of 2018 until August of 2019. I do want to clarify that. This is the only time period where she had insurance on the minor child. Even if we plug that number in and leave all of the other information as it should be, it still meets the variance. It is slight, but it still meets the variance. With regard to the attorney's fee award, I think it's clear from the record, and I believe I quoted directly from the transcript. Yes, counsel is correct. We were asked whether or not we were seeking attorney's fees. We both said yes. We had a sidebar, and at that time, we both agreed to waive attorney's fees, and I believe that that makes that a moot point for today. One of the things that counsel hit on was using the term deviation to refer to a child support credit. I will be honest, I have had a hard time in this case finding any case law whatsoever that distinguishes the difference between the additional credits that are in Section 8 for health insurance, for medical expenses, for work-related childcare. They are set apart from the deviation section, and I have not found a case that calls those items deviations. What I can find are lots of cases that give the court the discretion based upon the credibility of the parties and based upon the credibility of the evidence to determine what those numbers should be. For example, income, if there's an issue regarding gross income and how to calculate that. My understanding is the court has discretion to make those rulings and make those findings of facts. With regard to childcare expenses, several cases that you have heard yourselves regarding how to calculate and what credit to give for childcare related expenses, because as we know as parents, sometimes those childcare expenses far outweigh what it could cost someone to go work, and that has been an issue in the past. I've seen cases regarding those things. I have not been able to find a case specifically referring to health insurance premium and how that should be calculated and whether or not a parent should receive full credit for that. However, it does appear, based upon it being set apart and away from the deviation section, that the intent is possibly for the court to have discretion to determine what those numbers are for purposes of coming to the presumptive child support order number. Then at that point, there would be a deviation set apart, and it's clear based upon case law and based upon the child support guidelines, what you require to meet a deviation, and counsel is correct. It does require the two-step analysis. So I do have an issue with calling that what has happened in this case a deviation. I don't think it's a deviation, and I know that's for you to decide, but I think it was in the discretion of the court to determine how much credit to give each parent in those sections as an additional expense, just as they would for childcare or for medical expenses. Opposing counsel cites Jones versus Jones, and that is obviously a very important case. It did come around not too long after we implemented the child support guidelines back, I believe, in '93, and it sets out what deviations are, but it's very important to note in that case that at that time, they were completely different than what they are now. There were actually deviations specifically stated in there for extraordinary expenses, uncovered medical expenses, educational, as well as health insurance if it wasn't provided. They had those listed as deviations in the child support guidelines back in '93. Obviously, that's not the case today. The guidelines are very to the point and vague when it comes to health insurance. And that's all I have.
Okay, thank you, counsel. We'll hear from the appellant in rebuttal.
Thank you, Your Honors. To reply to this, first of all, the suggestion that we don't know who is covered by the mother's insurance, that there was no evidence presented. The mother very clearly testified that she had coverage for both of her children, and that's why she was only asking for credit for half of the cost of adding the children. And the costs of employee plus children, et cetera, those were all provided as exhibits to the court, and those are all in the record. So it's very clear by the testimony that this child was covered. Now, as far as the suggestion that this did not meet the 15% variance, of course, after hearing counsel say that, the question myself, I pulled it right up here on my laptop. That's the benefit of being on Zoom here. If we look at the court's order with each parent, mother at $33.45 for her income, father at $51.66 and 67 cents. Father gets $32.58 for the health insurance. Mother gets $693.33 for childcare, and that puts the obligation $840. The variance needed was $150, and that gave a $166 variance. That was the court's order. Now, if you take those exact numbers and simply add in $51.53 for mother in the health insurance premium section, that gives a variance of $133, which is less than the $150 required. So it does not meet the variance that is required. So the numbers very clearly say it doesn't meet the 15% variance just by adding that $51.53 for the health insurance premium. Now, I would say that this should be considered something like if you had a child care credit. Say father paid for work-related child care. Well, mother also had to pay for work-related child care. Mother gets credit because she's paying for it.
Well,
mother is.
What does the fact that the trial court ordered one of the parents specifically to provide this? I mean, is that not different from your example you're giving there about?
Well, I think that in the parenting plan has a little box to check for which parent is going to carry the health insurance, which parent has to carry health insurance. That there is not a box to check for which parent is going to pay for work-related childcare. So that is kind of an issue. It doesn't say mother's to pay for the work-related childcare, but she's getting a credit for it. In addition, the number of cases that I've seen where one parent is ordered to carry it, but another parent has to because they didn't. Is just a fact. It happens. You have to have health insurance for your child.
But that's not the case here. There was health insurance. Court found the father carried health insurance. And did the record show, does the record show that at least for a while, the health insurance that covered the child, that father had to cover the child, was the same that had covered the child during the marriage?
I don't believe that's in the record, Your Honor. And I think the important thing to note, while counsel's correct, she started this job in August of 2018, and they weren't officially divorced until after that. The divorce trial was in early July of 2018. So the fact that the final decree was not signed was simply because Mr. Abney's attorney didn't bother to file it. So typically,
I assume we don't know why it was.
Well, and it wasn't Miss Conklin at the time, so I'm not blaming her.
We don't know from the record why it wasn't filed. So
right, we don't know why it wasn't filed.
Let's keep it.
It wasn't filed.
To look at.
Right, and so typically, and what I always tell clients, I did not represent this client in her divorce, but I always tell clients you've got 30 days after your divorce to get new insurance. So you need to figure that out. And so this divorce was in early July. So when she was offered insurance in mid-August with her new job, she said, yes, I need insurance. I haven't been given new insurance for my kid. I need insurance. My kid needs insurance. I got divorced last month. The number of people that don't understand
Counsel, let me take you back. Again, one of my original questions was did your client offer any proof that she would not have gotten this coverage, including coverage for her other child, except to get coverage for the child of this marriage?
She did testify that she got this particular insurance because she had not been provided insurance for this child from Mr. Abney.
Okay.
That was the reason she got
I'm
the
sorry.
insurance.
So was her testimony that she wouldn't have provided insurance for her other child?
I don't know that was asked of her.
Okay. All
So
right.
I can't say for sure.
I understand.
I think that it all boils down to, even if the court did not want to give her credit for this, per the guidelines, she provided it and it should have been on the worksheet. The court could have then followed the guidelines and done a deviation by making the appropriate findings.
All right. Thank you, counsel. Court's thanks to counsel for both sides and for your oral argument today and your briefs. We appreciate them. If you would, please recess court until 2 p.m.
Thank you, Your Honor.
Thank you, judges. Thank
This
you.
Honorable Court of Appeals is in recess until 2 p.m.